Well, good evening, everyone. My name is Stephanie Kleyman. I'm a director of a local law firm, and tonight I am going to talk about how to avoid bad debt. As a solicitor and as a businesswoman, one of the biggest problems that we have is you do work for someone, you've spent a lot of time, invested a lot of money in winning the business, doing the business, and then you don't get paid, which of course is very frustrating. Sometimes you might come to somebody like me, a solicitor, and say, help me recover the money, and there's lots of things I can do. Often one of the first things I will say is, I wish I'd been with you at the beginning of the transaction, because there's so many things that I could have said, so much advice I could have given you about how to set things up, how to perform the contract, that would have significantly reduced the risk of it becoming a bad debt. And if it does become a bad debt, things that would have made it a lot easier for me to help you recover the money. So the purpose of tonight's talk is to try and share some of that knowledge with you to help you reduce the risk of having a bad debt. Now, bad debtors fall into two categories: those who can't pay and those who won't pay. Those that won't pay doesn't necessarily mean that they have that they're just being difficult. They might have a genuine dispute with the work that you've done, or the terms on which you've done it, or they might just be looking for an excuse to try and get out of payment. Sometimes that will come down to how clear the wording was in your original agreement. So it may be that there has been a genuine misunderstanding. It may be that they are just trying to exploit a genuine misunderstanding. So my first piece of advice is make sure that you have very clear terms and conditions. Now, that doesn't necessarily have to be something produced by a solicitor, although it's obviously the more professionally it's done, the clearer it's likely to be. It doesn't even have to be something that the parties have signed or something that is set out clearly in writing. A contract can come into play just from an exchange of emails. It could be at a meeting. It could be just on a handshake. People often come to me and say, there isn't a contract. Well, there almost certainly is. It just might not be in writing, or it might not be clear what the written agreement was. So the most important thing to do is to try as best you can to make sure that whatever it is you're doing is clearly set out in writing. There's a lot of information that needs to be confirmed. So here are just a few of the things that I would recommend that you do. First of all, make sure that it's clear who the parties to the agreement are. That might sound very obvious, but you might be surprised to learn how many people come to my office and say, I want you to sue these people, or I want you to chase these people for a debt. And when I say, yes, but who exactly are they? They won't know. So there are three entities that it could be. It could be a limited company, it could be a partnership, or it could be a sole trader. So you need to know who they are. This might be information that you'll find from their website. It might be information contained in emails that have been exchanged between you. But if at the outset it isn't clear, then it's not going to be any clearer by the time we finish. So when you come to me and say, help me collect this debt, if I don't know who we are pursuing, I might not be able to help you, or I might not be able to help you as easily as you would like. If it's not clear who the other party is, then that might mean that you can't issue proceedings, or it might mean that if you issue proceedings, any judgment you get isn't worth the paper that it's written on. So if the website says AB Trading, well, is that AB Trading Limited? Is that Fred trading as AB Trading? Is that Fred and Joe, a partnership, trading as AB Trading? Or is it something completely different? Is it Fred Blogs Limited trading as AB Trading? Unless we know that, we don't know who to pursue. So make sure you know exactly who your client is. And if it's not clear from the paperwork, ask them. Ask them to put it in writing to you. If they're honourable and genuine, then they'll be quite happy to confirm it, and their failure to make it clear on their website will be an innocent mistake. If they're trying to con you, then they'll be difficult about it, in which case the sooner you know what kind of people they are, the better. It's equally important to make sure that it's clear who you are. If you're going to issue proceedings, or if I'm going to issue proceedings on your behalf, it needs to be clear in what name you did the job, so that I know in what name to issue the proceedings. If you make a claim in your name, but actually it appeared to the other side that you were trading through a company, then they will defend the claim on the basis that you are not the appropriate person to be issuing proceedings. So you can save yourself a lot of time and money by making it clear at the outset who you are and making sure that you know who they are. Another important point is, what are the payment terms? Now, that's not just how much you're going to pay me, but it could be, when are you going to pay me? Sometimes people will say, well, I didn't expect to have to pay for the job until the end, whereas you might think that they should pay as you go along. Well, unless that's clearly set out in writing, we could spend a lot of time arguing about it, by which time the job could be done. So if you're expecting payment by instalments, if you are expecting an upfront payment, if your payment needs to be plus VAT, or you're going to be adding on expenses such as travel costs or things that you lay out for, then all of that should be set out clearly in an email exchange, or ideally in your terms and conditions or in a contract. Are you expecting to be able to charge interest if they don't pay on time? You do have the benefit of the Interest on Late Payments Act, which does give you an automatic right to claim 8% above base on outstanding invoices, but that's only business to business. So if you're providing services to individuals, then you can't rely on that. And in any event, I always think it's better to set these things out at the outset so there's no nasty surprises. An important thing to consider is who owns whatever it is you've done until it's been paid for. So imagine that you have supplied somebody with books, paperwork, perhaps a piece of writing. Who does that belong to until it's been paid for? Well, you're obviously going to say that it belongs to you, but unless it's set out in writing, that might be a hard argument to have. Possession, as they say, is 9/10 of the law. So if the item is on their premises, then your ability to say it belongs to you is going to be quite hard. If the other side haven't paid because they've got cash flow problems and they end up going into liquidation, well, the liquidator is not going to part with a valuable asset unless they absolutely have to. So if it's clearly set out in your terms and conditions or in any email exchange you've had that it is your view that it belongs to you until it's paid for, and they've agreed to that, then the liquidator is going to have nowhere to go, or it's going to be a much easier argument for you to have. It might be that you don't actually want it back, but that doesn't matter. It's a good negotiating tool. If the other side want it more than you do, you might insist on having it back or saying that they can't use it until it's been paid for, and that might help you get the money out of them, or at least enable you to do a deal. There's also a copyright issue. Who does the copyright belong to? Now, you might say that copyright belongs to them once they've paid, and that takes us back to the retention of title clause. But you might also say that copyright will never pass to them and it's always yours. So, for example, you might have produced a piece of artwork for them, and you are going to let them use that piece of artwork, perhaps on their website, and what they're buying from you is a license to use it, not the right to have it. That means two important things for you. One, it means that they can only use it for the one specific purpose that you've said. So if they then go on to use it for something else, such as letting someone else use it on their website, then you would have a claim for breach of copyright. But in addition, it means that you can use it. So if you want to use it on your website, or perhaps sell it again to somebody else, you have the right to do so. So if that's something that you are likely to want to do, then you need to make sure that that is clearly set out in writing and agreed to. Obviously, the purpose of setting out your terms and conditions is setting out what it is that you're doing for the money. So somewhere you want to make it clear what goods or services you are providing. And the clearer you can be about what those goods and services are, the less likely it is that there is going to be a dispute, or at least not a genuine dispute. So if you are going to be providing a service, then you want to be saying when you're going to provide that service, where you're going to provide it, how soon you're going to do it. If time is of the essence, that is something that needs to be clearly set out. That means that if you are going to say, I'm going to do it this week, well, if it drifts into Saturday, Sunday, maybe even early part of next week, if the other side, if your client hasn't said that that time is of the essence, then a minor delay might only give rise to perhaps a little bit of compensation. If, on the other hand, it's been made clear that time is of the essence, that it is urgent, or that's what they are going to say, then they might have a valid argument for saying that they are not going to pay you, or they're not going to pay you all the money for doing the job. And it might be much harder for you to argue with that. So again, all these things need to be set out somewhere in your emails. We talked earlier about making sure you know who your client is, who are the other side. You might want to think about who is actually going to pay you. So the client, the company that you are doing business with, they might say that a third party is going to pay you. Well, if that's the case, that's fine, but that needs to be clearly reflected in writing, and you need to make sure that that third party has agreed. So that might be a funder, perhaps, or a member of the family, if it's perhaps a startup business. If it is a company, you want to be having a good look at the company. Do they look like they're good for the money? Do they have a good credit rating? If you have doubts as to whether or not they are good for the money, think about, do you want more money up front? Do you want to think about getting one or all of the directors to give you some kind of personal guarantee? Personal guarantees are very serious documents. I would always advise against just having a paragraph in your contract that says, if the company doesn't pay them, the directors have to, because I think that can be hard to enforce. Never impossible, but there's a much bigger argument on behalf of the directors that perhaps they didn't understand the significance or the consequences of what they were signing. But if you do want a personal guarantee, make sure that it's clearly drawn up as a separate document and that they have had the opportunity to take independent legal advice and that they understand the consequences of what they're signing. If it's an individual or a partnership, so a group of individuals, there's nothing to stop you doing credit checks on them and making sure that they are good for the money. If they are good for the money, they should cooperate with you and they should be happy for you to carry out any checks that you deem necessary. And if they start objecting to anything like that, well, then I think you need to be asking yourself, why is it that they're unwilling to prove that they are good for the money? Now, when you're trying to agree terms with the other side, the ideal way is to have a properly drawn up contract or terms and conditions that are set out perhaps on your website. Not everyone has got the money or the budget for something like that. Sometimes smaller projects don't justify that kind of paperwork, although terms and conditions are something that you should be able to reuse time and time and time again. So what happens if you're having a lengthy exchange with someone about what the terms are? Well, it could be argued at the end that it isn't clear what the terms were because it's such a long exchange of emails and perhaps there's been a lot of backwards and forwards about how things are going to work in practice. In that situation, I would advise that before you start work, you do one email that summarizes the terms that have been agreed and ask the other side, ask your client to email back and confirm that that is what has been agreed. If you're using terms and conditions, then we sometimes have what's called the battle of the forms. This is where you say, right, we're relying on my terms and conditions, and the other side say, yes, I want to go ahead, but we're relying on my terms and conditions. And then each time there is an email, someone says, yes, it's my terms and conditions, and then the next email from the other side say, yes, it's my terms and conditions. So how do you decide whose terms and conditions are going to apply in the event that a dispute breaks out? Well, that's where the battle of the forms comes in, and it is the last shot in the battle. So what that means is the last person whose email went saying, we're relying on my terms and conditions, before the work actually started, that is the one that is going to be relied upon. So if you are having a little bit of a battle, make sure that it is clear either that they're relying on your terms and conditions or that you are satisfied with their terms and conditions. If for any reason you're not happy, then you need to stop and make sure that that is agreed before you end up doing any of the work and possibly having a dispute. So let's imagine you've done the work, you've put your invoice in, and there's a loud silence. No one's said anything. No one's paid you the money, but no one's come back and said, there's a problem. What do you do? Well, in my experience, first thing you're going to do is pick up the phone to them and say, is there a problem? Hopefully, it's just a misunderstanding. Checks got lost in the post. I'm sure we've all heard that a few times, and payment will be made. If they start raising disputes, you need to consider, are those disputes genuine? I would encourage them to put their complaints in writing. That's for two reasons. One, it makes it clear exactly what their complaints are so that you have got time to work through them carefully and see what answers you have. But also, it ties them down. It's much harder for them to raise further problems at a later stage if they haven't raised, if they've had the opportunity at the outset to raise them and they haven't, and then they raise them at a later stage. Well, then that is often a sign that they're just trying to delay for the sake of delaying. So when you're thinking about your terms and conditions, if you're going to draft them for yourself, one of the things you might say is that if someone is unhappy with your work, your goods, your services, that they need to tell you within a certain period of time, such as within 14 days. Whilst this isn't exclusive, just because you say 14 days doesn't automatically mean that they can't raise a dispute at a later stage, but it would give you some protection against a complaint further on. If their complaints make allegations of a counterclaim, that's another time that you might want to think about what you put in your terms and conditions. So, for example, sometimes in order to try and get out of a debt, somebody will say, your work wasn't good enough, and because your work was so poor, I suffered a loss. Your goods were substandard and I lost a contract, and now the people I was doing business with, they're going to sue me. And what will sometimes happen is they'll try and scare you off by saying, well, my counterclaim against you is twice as much as your claim against me. So if you're going to sue me, I'm going to sue you for twice as much. It's a fairly common tactic for people who don't want to pay. So when you're thinking about what you might want to put in your terms and conditions, consider whether it's reasonable to put in a restriction on how much liability you have to somebody else. So, for example, you might say that the maximum liability you could have to anyone else is 10% of your contract price, or 30% or 50%, or whatever you think is appropriate. But if you've set that out clearly in advance, then it will be much harder, never impossible, but much harder for someone to say, I've got a big counterclaim against you, and I'm going to use that to knock you out of the water. So, what other complaints might people bring? Well, they might say that you were late and that as a result, they terminated the contract. Well, let's have a look at your terms and conditions again. We talked earlier about having is time of the essence, and could people use that to claim compensation? But you also need to think about some kind of termination provisions. If you're just providing a one-off service, then that might not apply. But if you're providing a service that's on a rolling contract basis, perhaps something that you provide once a month, once a quarter, or that you just carry on providing it until they tell you to stop, then you want to think about what notice period do they have to give, what lead-in time do you need. If that is clearly set out in your terms and conditions and they haven't given you notice, and you've then rendered an invoice for a month's worth of services, then the fact that they haven't used those services or they don't need those services, that's not your problem. They had ample opportunity to terminate because it's clearly set out in your terms and conditions. They haven't taken advantage of that opportunity and you are entitled to your money. Now, they may say, well, that's not fair because I didn't use your services and so you haven't incurred any costs. There may be some merit in that, but I would start with what's in your terms and conditions and see what you can negotiate from there. Much might depend on how much the claim is worth and how likely it is that you think the client might come back to you in the future. So once you've established, is it a genuine dispute or is it just someone who can't pay or won't pay, you can decide what you want to do next. So before you start thinking about picking up the phone to me, much as I always like to hear from you, is there any room to negotiate? If they have a genuine complaint, how can you respond to that complaint and are you satisfied that you've answered all their allegations? There's a big benefit to inviting them to sit down around a table with you to talk about it. If they genuinely have a complaint, then they should welcome the opportunity to try and do a deal. If you don't think an informal mediation like that will work, you could think about formal mediation. It's only worth it if you're talking about a significant debt, but sitting with a professional mediator, we have one in the group. I'm sure some of you know Roger Levitt, who's very good at particularly property mediation. There are mediators out there that do areas other than mediation, and having somebody helping you to broker a deal can be hugely beneficial. If you do accept that you have done some wrong, that perhaps your performance, your service wasn't as good as you would normally expect, you might consider making some concession. It's worth doing if it is going to result in the matter being concluded quickly and if it means that you're going to get the majority of your money. So there's two ways in which you can do that. One is a without prejudice offer. Now, people often get without prejudice wrong, so let me just explain what it means. If you're going to say something on a without prejudice basis, it means that you are going to make some kind of concession that you do not want a judge to see. It is confidential between you and the other side. So if you're going to send a letter that says, I'm right and you're wrong and I haven't done anything wrong, then don't make it on a without prejudice basis, because that might mean that you can't show it to a judge at a later stage when you might want to. On the other hand, if you're going to admit that you've done something wrong, then you might want to make it on a without prejudice basis so that if you're unable to settle the claim and you end up going to court, you can claim for the whole amount without having to admit that perhaps you have done something wrong. So let's take an example. You've done some work, you've put in an invoice and it's for £10,000. And the client comes back and says, you were late and some of the product wasn't up to standard. So on an open basis, you can write and say, no, I don't accept that I did anything wrong. Yes, we were slightly late, but that didn't have any effect on you. The delay was of no consequence, and I'm perfectly entitled to my money. And then on a without prejudice basis, that's a separate letter that you head without prejudice. You will say, I said in my open letter that I don't accept I was wrong. I don't think I did anything significantly wrong, but I do understand that I was a bit late, and I do understand that some of the product wasn't quite up to my usual standard. So in order to resolve the matter quickly, I am willing to knock 10% off. I would suggest that if that's what you're going to do, you make it clear in the letter, in your without prejudice letter, that you're only going to give the the reduction once they agree to pay the balance. So don't go sending a credit note for the 10% until they've come back and said, yes, okay, fine, we agree to pay the remaining 90%. And even then, I would say, okay, fine, when you've paid the 90%, then I'll give you the credit note. It wouldn't be the first time that someone has said, yes, I accept, and then decided afterwards, no, actually, I think I'm entitled to a bit more. Once you've issued the credit note, well, that is something that would come to the court's attention. So that's a good way of negotiating in a safe environment. That means that you're not making any concessions, and it's a good negotiating tool. Now, you could go a little bit further, be clever, and do what is called a without prejudice savers to costs letter. And it's headed without prejudice savers to costs. It's exactly the same as I've explained before, but there's an added twist. When you say, I'll give you this discount, you then go on to say, but if you unreasonably reject this offer, then I will take you to court. And if I have to do that, and if the court agrees that I'm being reasonable and you unreasonably refuse to accept my offer, then I am going to go for costs at a much higher level than the cost than I would otherwise have been awarded. Now, the purpose of this is to put the other side at risk. It means that if they unreasonably refuse to enter into negotiations with you and try and settle, and if the judge thinks that they should have worked harder at it, then the judge can award them higher costs. And the reason you say that in the letter is you make it clear that you reserve your right to show the correspondence to the court, even though it's on a without prejudice basis. Although you can't show it to the court until the end. When the judge has made his decision, you can then show him your without prejudice save as to costs letter, and you can invite the judge to agree that they should have settled and that you are entitled to your costs at a much higher level. So what happens if they come back with a counter offer? Well, a counter offer automatically rejects your offer. Even if they don't expressly say so, that is the effect of a counter offer. So if you wrote and said, I'll knock 10% off, and they write back and say, we want 50% off, your 10% offer is now rejected. So what can you do? Well, obviously you can accept their offer if you feel that's a good thing to do, or you can make your own counter offer, but that will automatically reject their offer. So if you offer 10% reduction and they come back with, we want a 20% reduction, if you then respond with, I'll give you a 15% reduction, if they say no, take me to court, you can't then write and say, okay, fine, I'll take the 20%. Or you can, but they would be under no obligation to accept it. So if you're going to make a counteroffer, think carefully. Is there a risk that they could withdraw from the negotiations? And if they've done it on a without prejudice save as to costs basis, they could argue that you should have accepted their offer and you are then at risk at costs. So if you're going to make a counteroffer, think about what the implications are and what happens if you were to end up in front of a judge. So that deals with your terms and conditions, how to enter into a contract, the basics of the kinds of things you should be considering, and what happens if they don't pay. What are the first things you should do? So let's imagine that you've gone through all of that, you've done your terms and conditions, you've done the work, you've sent the invoice in, you've tried to get them to pay, but nothing's working. What are your options next? Okay, well, you've got two options. Well, got lots of options actually. First option is obviously do nothing. Whilst it's obviously always frustrating to have done work and not be paid, there's nothing to say that you have to take action or you have to take action immediately. A debt is valid for 6 years. So if you put in the invoice today, you've got 6 years from today to claim those fees. So you can issue proceedings at any time in the next 6 years and still be entitled to recover the money. So if cash flow is a bit tight for you, or you think that they don't have the money, but given a bit of time, they might come up with the money, you can just sit on it and wait and see what happens. Next alternative is write them a formal letter before action. Now, anyone can draft a letter, but there is a prescribed form in which you are supposed to send a letter before action before you issue proceedings. You can find them on the internet, and you can email me, and I can give you some details. If you don't send a proper letter before action, the other side have the right to apply to the court for your proceedings to be stayed, so that's put on hold, until you go through the proper process. The idea is to encourage the parties to correspond with each other, to try and resolve the matter amicably, and that court should be the last resort. So before you go off and issue proceedings, think about whether sending a letter before action is a good idea. Let's say you've sent your letter before action and you've had no response. Okay, what can you do now? You could issue county court proceedings. Now, people often talk about, I'm going to issue a claim in the small claims court. That's actually not how it works. You issue in the county court, and then the court decides which bit of the court you're going to: small claims, fast track, or multi-track. Small claims are claims of under £10,000, but it is at the court's discretion, and there are times where smaller claims could go to one of the other courts, or where bigger claims could go to small claims. Depends on the facts. The judge is going to look at if there are any complicated areas of law, if expert evidence is needed, number of other factors, and then decide. So whilst most claims of under £10,000 will go to small claims, it isn't automatic, and you cannot choose. It is at the court's discretion. We don't get a say. Do have the opportunity, obviously, to make representations as to why it should go to small claims, even perhaps if it's a bigger claim. So if it's a very straightforward debt collection claim for a larger amount, you could still have a go at putting into the small claims court, and then it's up to the judge to decide. So let's say that you've decided to issue proceedings. The first thing I would say is court action is a runaway train. Once you've started, it can be quite hard to withdraw. And if you withdraw, the other side could have the right to ask for costs against you, depending on the circumstances. So when you're doing your letter before action, don't threaten to issue proceedings unless you mean it. Or if you threaten to issue proceedings and you don't then go on and do it, there is no point in doing anything else. There is no point in keep sending more letters and more letters saying, I'm going to sue you, I'm going to sue you. Either do it, stop wasting your time. So if you've decided you're going to issue proceedings, be prepared to see it all the way through. Or at least be prepared that if you have to withdraw, there may possibly be cost consequences depending on at what stage you do it. Let's assume that it is a small claims matter and the court rightly sends it to small claims. What will happen? So you'll issue the proceedings. You can do it online these days. And the other side will have 14 days from when they receive your claim form to respond. And they are going to set out all the reasons why they haven't paid. They have got another 14 days in which to do that. So when you're drafting your claim form, make sure that you set out clearly what it is you're owed and why. The clearer you are, the easier it is for them to put in a defence that you are going to be able to understand. And the more likely it is that you're going to be able to resolve the matter. This may possibly be the first time that they have told you why they haven't paid. And so the sooner you get that information in a clear format, the better. When I'm drafting a particular claim to go to court with a claim form, I often do it in numbered paragraphs. I'll say who I am, who the other side are, what works have been done, when they were done, what invoices were rendered. if the other side have given a reason why they haven't paid, I might say what their explanation is and what I say to that, just to preempt it. So once you get their defence, you can have a read through. Maybe that will help you understand what this debt is all about, and maybe that will give you the opportunity to pick up the phone to the other side and see if you can have a conversation with them to resolve it. Again, if you're going to make any kind of concessions, even verbal ones, say that you are saying it on a without prejudice basis. So you can even start the conversation with, can we talk without prejudice? And then you can have an open discussion where each side is free to make concessions. If you are going to do anything over the phone of this type, make sure that you have a clear attendance note. You write down a quick note of who you spoke to and who said what. If you're unable to reach a resolution with them, then you've now got two documents. You've got your claim form where you set out what you're owed, and you've got their defence saying why they haven't paid. The court will then send you an allocation questionnaire. This is, each side gets an allocation questionnaire, and you set out some administrative information. What court you think the final hearing should be in, how many witnesses you're going to call, how many documents you have, do you need any expert evidence, are you likely to need any interpreters, have you got any dates to avoid. This is all the information that the court needs in order to decide the what, where, when, how the trial is going to take place. This is also the point at which the court will decide if you're going to small claims. So if you are concerned that it might not go to small claims, this is the ideal opportunity to set out why it's a small claims case. Both sides have to do this. There will be a timetable by which you have to do this, and then the court will make a decision. Now, along the way, there are things for you to do, there are things for the other side to do. What happens if someone misses a deadline? So we talked about how the defendant, your ex-client, has got to put in a defence. What happens if they don't? You can apply for a default judgment. This is a form that the court will have sent you, and you just fill it in and you send it back. What happens if they don't do their allocation questionnaire? The court can order that if they fail to do it by a particular time, that you can enter judgment against them, and that's great. What happens if you don't get your allocation questionnaire in? Well, that could mean that your claim gets struck out. So when you send the papers off to the court, and on a regular basis, be in contact with the court, find out what's going on. Wouldn't be the first time that the court has a record that they've sent papers out to you, but you haven't received them. So you're sitting there waiting for perhaps your allocation questionnaire, and they're waiting for you to send it in, and you don't send it in, and they might strike you out. So make sure you keep in touch with the court on a regular basis so that you don't get caught out. So you've put in your allocation questionnaire, they've put in their allocation questionnaire, and the judge has reviewed it. What's he going to do? Well, he's going to set a directions timetable. He's going to set out where the trial is going to be, and he's going to say what the parties have to do before the trial. The most likely thing is that he will say that 14 days before the trial date, each side has to send to the other their witness statements and their documents. Now, this is very straightforward. What you need to do is consider what are the relevant facts, what work you did, when you did it, why you did it, how you did it, and you're going to put this in a document, numbered paragraphs, where you set out clearly the story. Imagine you are sitting in front of me and you are just going to tell me in short bullet points what happened. You might talk about what communications you've had with the other side, what explanation they've given as to why they haven't paid, and you might talk about you should talk about your answers to that, but why these points aren't valid. You also want to put together all your documents. Now, this is somewhere where people can sometimes go wrong in their preparation because they'll only put in the documents that they want the judge to see. Well, you have to put in everything, even if they are things that are not necessarily to your benefit. But disclosure is an open process where you have to show the judge everything, warts and all. The only exception to that is, of course, you are not going to show the judge any without prejudice documents. So you're going to get all your documents together, you're going to send them to the other side with your witness statements, and you're going to put together a bundle that you're going to send to the judge. You're going to keep a copy of the bundle for yourself, and you're going to take it along to the hearing. They're not nearly as scary as they sound. It's nothing like you see on TV. A small claims trial will be sitting down around a table with the judge at one end and you and the other side facing each other at the other end. It's quite informal, and you will have the opportunity to refer to your notes. You will get a chance to have your say, explain to the judge what it's all about. The other side get a chance to have their say, talk about what it's all about, and then the judge will ask some questions and he will make a decision. What I should prepare you for is the amount of time you may well end up sitting at court waiting for the judge to see you. Most court advocates, litigators will tell you that we spend a lot of time sitting around and waiting in court. Hopefully that will then lead you to a satisfactory resolution. Don't forget, whilst you are sitting around in court waiting for the judge to see you, there's nothing to stop you going and approaching the other side and seeing if a deal can be done. But make sure, again, that you discuss it on a without prejudice basis so that no concessions can be repeated to the judge. So then, by the end of that process, you will hopefully have ended up with a judgment. Once you've got your judgment, send it to the other side, invite them to pay it within 14 days, and hopefully that's the end of the matter and your bad debt is gone. But what happens if they don't pay? Well, provided that you've got the information on the judgment correct, you've got the correct name, you've got the correct address, as we discussed at the beginning, now you can think about enforcement proceedings, how to get the bad debt paid by hook or by crook. Okay, so you could send the bailiffs in. I'm sure we've all seen the TV programs about can't pay and we'll take it away. That's pretty close to how it actually works. I'm a big fan of the bailiffs. I also like using the sheriffs, that's the High Court equivalent to the bailiffs. So if it's a debt of over £5,000, then there's no reason why you can't transfer it up to the High Court and get them to enforce it. County court bailiffs are very good, but they can be slow. You can wait a long time for the bailiffs to go round. Bailiffs and sheriffs do not have the right of peaceful entry to residential premises. So if your claim is against an individual, then they can only get into the house if they're allowed in. Otherwise, they can only take assets that are outside, and often cars and the like are on finance, so that's not going to get you very far. If your debt is against a business, then they have the right to go into the business and they can start taking assets. They can take laptops, furniture, equipment, any one of a number of things. The problem is that these kinds of products do not get a lot of money at auction. So the chances of getting a lot of your money back is pretty remote. Your best chance with a bailiff or a sheriff is that your ex-client is more worried about losing their assets than they are about paying you. And at that point, they will get their checkbook out. As you've probably seen on these programs, the bailiffs and the sheriffs are quite good at negotiating deals, and they are good at explaining what someone's rights are. So if they can get to speak to someone, there's a good chance that they will collect your bad debt for you. But what happens if the bailiffs can't find anything? Okay, other options. If your client has ever paid you by a check, see if you can get a copy of that check. In fact, if clients do ever pay you by check, take a copy of the check and keep it on your file. If you have any details about your client's bank accounts, then you can make an application to the court for an order to freeze their bank account, and that any money up to the value of your judgment plus costs has to be paid out to you. even if there's no money or very little money in their bank account, the sheer inconvenience of having their bank account frozen and the effect that that will have on their credit rating can induce them to come and pay your bad debt. Okay, what other options do you have? Well, if you know, if it's an individual and you know where they work, well, you can make an application to have money taken out of their salary every month. And again, that can be quite embarrassing for them. And that, as with having the bailiffs turn up, that can induce them to want to pay you and get rid of you. Even if it doesn't, then having the money paid from your bank account, from your salary every month will at least eventually mean that you get paid. If you know any property or assets that they own, a house perhaps, then you can apply for an order a charging order. You're not going to get an order for sale. You'd need a claim of at least £20,000 for an order that the property be sold and you be paid out of the proceeds. But at least if you put a charge over the property, that means that other people will become aware of it. So there might be some embarrassment factor. It means that if they are going to want to sell the property or remortgage it, they're going to have to pay you off first. So that's another way to get rid of your bad debt. Certainly if you're corresponding with someone, let's say, before you've gone to court, someone is saying that they want to pay you, but they just don't have the money. Offering to have a charge over their property is another way that you could avoid a bad debt, because at least if you've got the charge over their property, again, it might be some time before you get paid, but at least you know you're going to get paid eventually. If you're going to have a charge over their property without it being something that you've done through court, then it has to be with their consent. You can't just get a charge over their property because you say so. You'd have to go through the court process to prove that you were right. But if they agree that they owe you the money and they agree to you having a charge over the property, then that might at least give you some comfort that you're going to get paid eventually, even if it's a way down the line. Okay, last but definitely by no means least, insolvency. This is something that I think is useful to threaten people with or use to persuade them with. Even before you've even thought about court proceedings. This is another way to avoid having a bad debt. If they've admitted the debt or they don't have any valid defence, then when you do your letter before action, you can suggest to them that in the absence of a satisfactory response, you are going to consider insolvency proceedings. So if it's a company that owes you more than £750 or an individual who owes you more than £5,000, you could go straight for bankruptcy proceedings or insolvency proceedings. So threatening that in the letter before action or saying that to them over the phone, I'm very sorry, but this is a course of action I will have to go through if you're unwilling or unable to do a deal with me, can focus people's attention on the importance of making sure that a deal is done. But if that isn't possible and you've got your judgment and you can't find any other way of getting paid, then serving them with a statutory demand, which is the normal way of starting insolvency proceedings, can again focus their attention on paying you. It may be that they've got cash flow problems and that they are borderline insolvent, but in my experience, they are going to pay the people that shout the loudest. So if they've got a number of people that they owe money to and they think they can fob the other people off, but they don't think they're going to be able to fob you off, they're more likely to pay you, whoever shouts loudest. So do consider whether or not you want to do insolvency proceedings and serve them with a statutory demand. A statutory demand is a very simple document, doesn't cost a lot of money to prepare, and there are no court fees involved. You just have to make sure that it is served on them. So if it's an individual, it has to be served on them personally. If it's a company, it has to be served on their registered office address. I wouldn't use a statutory demand unless I was certain that I could prove the money was owed. So that's either a county court judgment or an admission of liability. Having said that, it is sometimes used as a tactic to make sure to focus someone's attention. But that should be used with a great deal of caution. If you serve them with a stat demand and that gets them to negotiate with you, gets them to a deal with you, well, then that's great. Then it was worth doing. If they don't, if that doesn't bring them to the negotiating table, then the next step would be issuing a bankruptcy petition. That is quite expensive. The petition itself is not a huge amount of money to prepare, but the court fees are quite expensive. It's in the region of £1,200 to £1,500, depending on whether it's an individual or a company. Now, if you do a deal with someone and you withdraw the petition, you'll get about £1,000 of that back. But if the petition is granted and the person is made bankrupt, or the company is put into liquidation, then that money is gone unless the liquidator finds assets. The insolvency process, it's quite straightforward. Petition goes in front of a judge. Judge hears the evidence. Might be a few adjournments. Judges do not like making people bankrupt, and they do not like liquidating companies. So if there's any reason to believe that either the debt is contested or that there is the chance that payment can be made, the court is going to allow them time. People often say to me, but I've got a judgment, how can they contest it? Trust me, that's not going to stop them. And I often have people turn up at court saying, I didn't know you've got a judgment against me, I'm going to apply to have it set aside. And the court will allow them a bit of time. So you are going to have to be patient if you go down this route, which is why right back at the beginning, I talked about making sure that the people you're doing business with are good for the money, because the time and money that you can spend trying to enforce a bad debt can be time consuming, expensive, and there is always the possibility that you'll get to the end and find that there is no money left anyway. So let's say that you've done your stat demand, no response, you've issued your petition, still no response, you've gone to court and the person has been made bankrupt or the company has been put into liquidation. What happens then? Well, a liquidator will be appointed and they will collect in all the assets and they will pay off the liabilities. That makes it sound like, right, we're finally getting somewhere, I'm going to get my money. Well, possibly, but I'm afraid that's quite unusual. If we get to the point of putting a company into liquidation, the probability is that there is no money left. If they had money, they'd have paid you to stop you putting them into liquidation. Sometimes it happens that the business can be sold as a going concern and some money can be realised. Sometimes it will turn out that although they had no cash in the bank, they had assets, and once the assets are sold, there is some money to be spread out amongst the creditors. It's also worth being aware that if you are the person that's put the company into liquidation, you might think, well, that means I jump the queue. No, it doesn't. It means that you'll get your costs back first, it's the cost of the petition, but for the debt itself, you're just going to rank in with all of the others. So, having gone through all of that, let's go back to the beginning. And if you're going into business with someone, particularly if it's someone you haven't done business with before, it is very important that you know exactly who it is you're doing business with, what terms you're doing business with them on, and as far as you can, that they are good for the money. The clearer your terms and conditions can be, the clearer your exchange of emails, the better the communication between you and the other side, the less risk there is that you might end up in a situation where you have to go all the way through the court process in order to try and collect your money, with the risk always that there will be no money left for you at the end. I mentioned in the middle that you always have the option of doing nothing, because no matter how frustrating it is to have spent all this time and money winning the work and then doing the work, to not be paid is soul destroying. And I understand that as a businesswoman. But having illustrated all the things that could possibly go wrong, and how expensive litigation can be and how draining it can be emotionally, my advice would always be, don't start court proceedings unless you are as certain as you can be that there is a reasonable prospect that you are going to get paid. And taking a step back, don't start working for somebody unless you've got clear terms and conditions and you are as certain as you can be that you are going to get paid. And think about what protection you can put in place for yourself. The extent to which you can have deposits, the extent to which you can have security, the extent to which you might have personal guarantees, and what you need to do in order to make sure that you don't have bad debts. Payment by instalments is always a good one, with a condition in your terms and conditions that if any invoice is outstanding for, let's say, more than 14 days, you have the right to down tools and stop work. The more willing your client is to agree to terms like this, the greater the chances are that they are good for the money and they have every intention of paying. The more resistant they are to terms like this, the more you should be concerned as to what the risks are. One final piece of advice I have is to consider references, particularly if it's somebody you haven't done business with before. One of the great things about being a networker is the ability to talk to other people in the network about what they know about someone and if anyone's had any bad experiences. If people can vouch for them, if people can say, yes, I've never had any problems getting paid, most obviously that isn't a guarantee. Things change, things go wrong. If no one is saying anything bad about them and everyone is saying good things about them, then that's obviously a good indication. So I've now talked solidly for an hour and I'm not quite sure how my voice has held up, but I hope that's given you 50% on what to do to make sure that you've got everything in place, 50% on what to do if things do go wrong and how to try and get as much money back as you can. But if anyone has any questions, if anyone wants any information, if anyone would like me to look at their terms and conditions and let them know whether or not I think that would give you adequate protection or what improvements we can make to give you better protection, then I would be delighted to hear from you. My name is Stephanie Kleyman. I'm a director of Kleyman Co Solicitors. We're based in Whetstone, and I've thoroughly enjoyed chatting. I hope you've enjoyed listening. Many thanks.